Thank you very much. We're going to try and not do a long resume of who we are, but I'm Nils. I do defence and claimant work. I worked also on Sainsbury's as the expert all those years ago, and I work a lot on other claimant things in the UK, but also defence on the continent. To my left, Rob, would you like to introduce yourself?
I'm Rob Murray, I'm a solicitor. I also did Sainsbury's with Nils. I've done a number of other cases, launching air cargo, Le Paterol, some work for Microsoft, and I've been doing it since 2008.
Last but not least, Jason.
Thanks, Nils. Yes, I'm a managing associate at Linklaters, tend to do defence side work. I've worked on a range of competition litigation matters. I'm hoping not to be cross-examined, bearing in mind that we've acted for Visa for a long time on the interchange fee litigation, and I'm obviously sat with two folks who've very close to it from the claimant side. On top of that, worked in a number of different sectors, the water class actions, and also advised the Premier League in relation to the ill-fated European Super League project.
Thank you. I noticed he already said he doesn't like cross-examination, bit of a shame. But what we're going to try and do is have a little fireside chat over some topics that, frankly, especially for the UK, but we'll try and actually roll them out to the extent to Europe, that they apply to Europe. In particular, limitation, issue of limitation, thinking about the framework for competition cases, opt-in, opt-out, and then, obviously, the fraught issue of certification and how one actually goes about it or thinking about it. And if we have time, we'll go on to our dreaded subject called pass on. We're going to try and have questions at the end. So I know that everyone had about 3 minutes for one question. We're going to try and get questions. But I just wanted to start off with that very lovely topic of limitation. And could you just outline for that lay economist that I am, how they actually work in the UK?
Yeah, sure. I mean, it's such an important topic in terms of a building block for any claim. You know, what is the scope of the claim you're bringing or you're up against? What's the time period? What are the damages? And that obviously has huge knock-on effects in terms of scope of disclosure, scope of evidence, all manner of other issues. You know, ultimately going then how to try this claim. So, just to cover it briefly from a UK perspective, I think the key point to sort of split this on is the 9th of March 2017 and the damages directive. So prior to that period, under English law, we've got the usual 6-year limitation period from when loss was suffered. That period could be extended where there is a deliberate concealment of the action that the claimant might want to bring. And in those circumstances, that period can be frozen if it was concealed or up until the point at which, with reasonable diligence, a claimant would have been able to discover the relevant information. Turning to the second part of that then, so when the damages directive comes in, the changes we have there is that the UK rules say that it only applies in respect of an infringement that takes place and loss or damage is suffered on or after that date, so the 9th of March 2017. Limitation period is still 6 years, so you might ask the question of, well, so what? What changes then? But there are a couple of important differences. The period doesn't start to run until the later of the infringement ceasing or the claimant knowing about the infringer's behaviour, the infringer's identity, and that the behaviour is an infringement of competition law, and that the claimant has suffered loss or damage as a result. So just to unpack that ever so slightly, what we're seeing is, firstly, an expansion of what a claimant would need to know in order to sort of trigger the limitation period starting. And then secondly, the introduction of this new concept that the infringement has to have ceased. So you see there that there is, I think it's fair to say, a claimant-friendly expansion of limitation periods from a UK law perspective for that period post-damages directive.
Now, I seem to recall there's as an important judgment, the Volvo one, and also the DAF litigation.
Yeah.
How does that actually impact on the damages directive limitation period?
Yeah, so I'll try to deal with that in two parts, if I may. So the first, if we focus on the Volvo judgment itself, and then perhaps we can look at its application in the English courts at the moment, and in our favourite topic of the interchange fee litigation. So just to take the judgment in the first instance, I think just to set the scene on that, we got a judgment in July last year in relation to Volvo. That was a reference from the Spanish courts in relation to a trucks cartel claim. The deadline for member states to transpose the damages directive was 27th of December 2016, and Spain didn't do so until May the following year. And the infringement in that case was found to have taken place from 1997 to 2011. The importance of that is that the CJEU had ruled that the limitation provisions of the damages directive didn't apply retrospectively. So on the face of it, they wouldn't have applied to the trucks cartel. Where we then suddenly see this shift is that the CJEU said that as a general aspect of the principle of effectiveness, time limits could not start to run until the infringement had ceased and the claimant had knowledge, sufficient knowledge to bring the claim, so effectively the damages directive position. The court concluded that on the case before it, the claimant could not have known the necessary elements to plead the case until the Commission published the summary of the infringement decision. And the consequences of that was that the limitation period had not expired by the deadline of the implementing of the damages directive. Now, the key part then is that the CJU, and I confess, with all respect to the CJU, I think this aspect of the judgment is slightly odd, then went on to say that this meant that the limitation rules in the damages directive would apply to this case, and essentially the provision in the damages directive that said that it would not apply retrospectively did not, according to the CJEU, stop it applying to older claims if the limitation period had not expired. Now, where that feels counterintuitive to me is that you would expect not retrospective to mean that new limitation rules only apply to infringements which took place after it was introduced. So you had this quite limited part of the CJEU's judgment that commented on this, but I think sort of set hairs running in terms of, well, what is the impact then on limitation periods? Now, to go to the second part of the question, Nils, the CAT said, having looked at this in the context of the interchange fee litigation, and for those of you getting deja vu, this is the second time in the interchange fee litigation we've had the debate of can claims go back to 1977. For my own sanity, from a disclosure perspective, I'd be very glad if they did not. But the CAT said that although the CJU had briefly articulated that limitation could not run until an infringement had ceased, that point was commentary and not the operative part of its decision, which meant that it was not binding, and obviously post-Brexit, it wouldn't be binding in any event. So in light of that, the tribunal refused to follow the European Court's comments about the need for the infringement to have ceased, and it said that this was, it saw those comments as a dramatic expansion of the principle of effectiveness. It felt that the CJU hadn't given any reasoning for that point, and in any event, it noted that it was bound by a Court of Appeal decision that I mentioned a moment ago, previously saying that limitation periods under UK law were sufficient to meet the principle of effectiveness.
Does that mean everything's settled in the UK?
It doesn't. I'll tackle a couple of very narrow points on this, mindful of time. So technically, it's possible that the English courts could decide that the principle of effectiveness requires a claimant to have knowledge of more matters than the deliberate concealment test. My own view is that it's unlikely to do so. We've got well-established principles on that front that have been going for some time and are grounded in legislation. And the tribunal also didn't comprehensively deal with the European Court's finding that any claims where limitation had not expired would be within the temporal scope of the directive. They said they thought that this was a bold view that the CJU had set forward. As I've said, to my mind, it felt like a counterintuitive part of the CJU judgment. I mean, it remains to be seen as we get further along, if these are points that end up in appeal. how they play out.
Just, Rob, could you just comment just in terms of the European playing field?
Yeah, I think the main point is that at least for some cases, the judgment might have some kind of levelling effect, one way or the other. And I think there's a reference to Hurricane case, so that even at the European level, the issue is not over. But obviously, that could have quite important ramifications because even with the damages directive, I think it's fair to say that there is not a level playing field in Europe on limitation, and that has all the consequences that you mentioned earlier in terms of potential scope of cases, etc.
Yeah, I think the challenge there has been, it's often been seen at European level as a matter for domestic courts, domestic legislation, and now we're seeing an effort to harmonise and create, as you say, Robert, a level playing field. That's going to take some time, and obviously in the case of the UK, Brexit means Brexit, as we all know, so query, whether it actually has any impact here whatsoever.
I was going to do my usual joke at conferences that we'll be discussing Article 101 when the UK goes back in. Is it a joke? Well, actually, I would like to get on to a subject matter that I personally find very fascinating, and that's really the choice of opt-in and opt-out. And just coming to that, what is the framework for a collective proceeding? I think, Rob, you start off and we'll all pile in afterwards.
Yeah, I think before we get into the weeds, I think it's worth standing back and reminding ourselves why we have the collective regime and what the public policy issues are there. And essentially, it was introduced because various cases prior to it had highlighted the lack of effective redress, and one of the famous cases was the football replica shirts case, an opt-in case brought by which the Consumer Association. There were others, including air cargo, with the failure of the representative action there. And we are obviously in this room focused on the private side of it, which is damages for redress for harm caused to either businesses or consumers. But I think it's important to remember that there's a lot of public policy considerations behind that, not least the principle that private enforcement with public enforcement can have deterrence effect. So it's not just vindicating individual rights, it's also trying to change the behavior of businesses. But there are other public policy considerations, not least the judicial efficiency that this might introduce, a level of consumer protection, and that led to the use of the CAT as a specialist tribunal, and the decision of the lawmakers to try this out just with competition law. I mean, the original proposals were broader than that, but they got cold feet about a broader right. So then looking at the more at the detail, I mean, opt-in, opt-out is really a choice in relation primarily to businesses. I mean, opt-in is not going to be relevant to consumers because that's what the opt-out is clearly for. So you're really talking probably in practice about direct purchases, for example, in most competition cases. And the question is, well, what's the choice open to those businesses? And actually the choice for businesses is wider than the choice of the opt-in collective proceeding or the opt-out collective proceeding. And yet again, in interchange, we see that with the umbrella proceeding cases with the merchants. But fundamentally, I think the reality is that it's a question of, can a case be viable on an opt-in basis? And if so, can it then extend to the class of people who have suffered? And those are not necessarily the same situation. It's possible that a case could be viable on an opt-in basis, but it would be very difficult to then notify and bring in all the other people that have suffered harm. And that was a point raised by Paul Lomas in his dissenting judgment in the Forex decision, and the recently reissued decision of the Court of Appeal basically follows the Lomas dissenting minority view. Yep. So you've now got a situation where the Court of Appeal has quite forensically looked at what the CAT did in 4X and said that they got it largely wrong, and that they instead need to certify the claim as an opt-out. And the guts of what the Court of Appeal said was the test in 79.3 is at large. It's all factors you consider relevant, and the Court of Appeal has a very broad discretion. So it's not just about the strength of the claim or the practicability issue, it's everything. And I think where you get to is the Court of Appeal said the strength has got nothing to do in most cases with this issue, so ignore that. And it does boil down to practicability. And practicability is basically, can you get the claim funded? Because the reality now is that even large corporates with the ability to bring other cases in other ways generally don't want to put their own capital at risk. So I think that's probably where we get to post the reissued judgment.
Do you want to say anything, Jason?
I don't think so. I mean that captures it neatly, as you say. I mean, we've seen this sort of tension that's been going on for some time, and I think at the outset we had, as you say, what feels like a business-based role for opt-in claims. I think there was some tension because FX on its face looked like one that could maybe be almost an archetypal sort of poster boy for the opt-in mechanism. And now, obviously, with the Court of Appeal's judgment, we've seen that that's not the case, and that it's back to the drawing board, and it's one that will proceed on an opt-out basis. I think when you look statistically at the number of claims that we're seeing and how they are being brought, we are seeing so few opt-in claims, and where we are seeing them, they're brought sometimes twinned with an opt-out mechanism as well. So, I mean, it will be interesting to see as the regime continues to develop whether there is, more of a place for opt-in and where that will genuinely feature. But for now, it certainly seems to be the case that it's, we're seeing the vast majority of claims on an opt-out basis, and that is something that the Court of Appeal decision seems to be suggesting is, something that it's comfortable with in terms of the way the regime's shaped up.
Yeah, I think where it kicks off is when the legislation was framed. I think there was still an overwhelming desire to avoid anything that looked like a US class action system. So I think, and also there was no real history of the concept of an opt-out type claim, and the one provision in the rules that was effectively an opt-out, the representative action, was almost never used and was considered to be more or less useless. And the reality is that it's the opt-out that's the guts of achieving the policy objectives. And in many ways, opt-ins are not necessarily judicially very efficient, not least because they require individual loss to be shown. And again, going back to the funding point, in 4X, there was an enormous amount of money spent on an attempt to build a book of opt-in claimants. I mean, the stats were that the law firm approached 321 institutions and managed to get 14 sort of provisional retainers. They spent millions of pounds doing that. They provided the CAT with data about the claims of the institutions. And one of the things that the Court of Appeal said was that the CAT drew the wrong conclusion from that data. And effectively, the CAT looked at an average claim value and said, well, that looks pretty decent to us. Some people are going to get a lot more, so it should be opt-in. And the Court of Appeal said what really counted was, so that was the mean, and what really counted was the mode, which was that the vast majority of claims were around about 16 grand. And there's an annex to the decision with that data. So I think what that leaves, the conundrum, is where you have a class which would contain lots of sophisticated corporates, do you even do an attempt at a book build? It's going to cost money. If it fails, you might get the opt-out anyway. So where does that leave opt-in as a mechanism? And so I think there will be even fewer opt-in cases now than there have been.
Well, and the point that would obviously be brought where you do the book build case and you are broadly unsuccessful in terms of getting appetite is obviously defendant will naturally be pointing to it and saying, well, that's because no one wants this claim, so there's no appetite for it, so it shouldn't be brought.
But as a collective action.
As a collective action.
Yes, yes.
But that was effectively the argument that was rejected.
Yes, quite.
In Forex. But I think Forex shows, and I think opt-in is very difficult on this question to have a sort of general rule, and I think that's why the rule itself is look at everything and decide on the facts. And, you know, one of the most important things are the facts. And even a very large corporate may or may not have a reason to be part of a collective proceeding, but nevertheless have suffered harm. So that factual analysis will be key, but as I say, my sense is that people are going to say, well, why do we really need to go there? There are cases involving large companies. We've got Forex. Opt-out is, on the face of it, has some major advantages from the claimant perspective and therefore from a funding perspective.
Can I just, and this obviously it's not part of the script, so but on the idea between opt-in and opt-out at the merchant level, not at the consumer level, and how cases are brought, because part of the problem we're facing, okay, let's call it again interchange, but other cases, maybe I'll say big tech, you have plenty of consumer claims, but there's no corresponding merchant claim to gather evidence. So when we talk about other issues, not just simply volume of commerce or anything else, but actually on pass-on, how does one determine actually who has actually suffered the harm without having sufficient number of opt-in claims at the merchant level? I mean, that's one thing we may want to get into later on. What I'd like to actually turn to now is certification. I mean, it's only, where are we, November? February we had the Meta judgment. I do recall that because at that point I was supposed to write an expert report, as Jason will well know. I think on the same day it came out, Meta, I was then instructed a different way on how to write my expert report on methodology for damages. And was it simply about damages, or was it something more? We've seen since February Court of Appeal talking about this. We've seen in the last week and a half, I think it's Boyle, which in a way is 180 degrees different from the commercial cards judgment from the CAT. So different tribunals saying kind of different things. I'll hand it to Rob because I don't want to torture Jason too much. Rob, why don't you just comment on certification a bit?
Well, I think the charitable view is, let's say, that the approach has ebbed and flowed in the CAT. It goes again, I would start with, you know, at the top level, go back to, you know, the leading case, Supreme Court Merrick's. That contains what you need to know about certification because it puts it in the context of the purpose of the legislation and makes it very clear that certification should be a pretty low bar, bearing in mind that the CAT also has the power to strike out. So, you know, that's a low bar. And that it's not a mini trial. And critically, I think, there's a recognition that future developments, not least in relation to disclosure, will, as in the normal way of any case in an English court, may well lead to the scope of the claim changing. I mean, it's perfectly normal for pleadings to be amended, for things to be added, arguably the same cause of action or not. It's well-trodden path. And so we have gone through a sort of series of cases, as Nils outlined, but I think where we get to, and this is supported by the recent Court of Appeal decision, I think, in FX, is that we're back to a relatively low bar. And on the issue of, I mean, I think the point that is often missed is that certification is not a one-off decision. Certification is an ongoing process. So the CAT can revisit the issues that it might have struggled with when certifying and indeed will. I mean, it's quite clear in some of the cases where the CAT has said we won't strike out, we'll give you 6 months to replead, and told people, by the way, don't bother repleading those 2 courses of action. You know, try that one, and we'll see. So, and that seems to me entirely the right approach, because it reflects reality, and it grounds cases back into the facts. I mean, the mad thing about the Forex decision of the CAT was, it was a fact that if you certified it as an opt-in, it would not happen. And yet that's exactly what they did. And that was what has been overturned. So again, it's a question of reality. And on the issue of methodology, it's really a question of if it is the Microsoft process test which is being applied, and certainly that's what all the cases say it is, then you only really need to read that test to realize it's limited to the issue of aggregate damages. It does not cover things like liability. That's not to say that a case doesn't have to say something about how liability is going to be proved if it's actually a standalone case. But that's not necessarily something that is for an expert report. It might be a mixture of law and expert and fact.
Just to add on that, I think that's right on the sort of ebb and flow, and also that, you know, the bar objectively doesn't look to be particularly high. I think what you see is that, you know, the CAT has a gatekeeper role, and I know we're going to come on to decertification. It's almost not even a claimant versus defendant point, but more of one that goes back to the origins of the regime of consumer protection, in the sense that what the tests are really looking at is this claim viable? Is this claim triable? Does it have fundamental issues in being brought? Where we're looking at a regime which, as we've discussed already, is, you know, we're seeing it weighted heavily in favour of opt-out claims being brought. By its nature, that means we're talking about underlying individuals, businesses, whoever it may be, potentially with no idea of a claim that is being brought, and they will be bound by the outcome of a claim that is going to be tried. So as a matter of sort of consumer protection, when you think about it, it's important to make sure that the claims, not just to protect parties and the tribunal from incurring significant costs if it's going to be wasted because the claim has no legs to it, but also to make sure that if there are, you know, large groups of individuals, businesses, whoever it may be, being represented as a class, that the claim is one that is viable and triable if that's going ahead.
Yeah, and that actually goes back to an important aspect of the opt-in, opt-out debate, which is the nature of the opt-out. There's clearly some judicial concern that somehow the class rep is not going to be able to control the lawyers and the funders. And the Court of Appeal said, well, look, this system has to have the lawyers and the funders, otherwise it won't work. It's actually designed this way, so that is not a factor at all, cannot be relevant to the opt-in, opt-out. It's just a system attribute. And then you think, well, that goes to the issue of practicality and funding. And again, one of the other aspects was this idea that maybe it would be better to have a trade body as the class rep, because they might somehow be better at controlling the case, and the Court of Appeal said, meh, not really. And then the other aspect of it is that well, no, actually, I'll stop there. Well, I'll give a suggestion. I wasn't sure whether to suggest this, but looking at these issues in the round, certification, opt-in, opt-out, I can't help feeling that it might be a good idea to educate the members of the CAT by giving them a bundle of papers and saying, we'd like you to write the funding application. Here's a potential case. Have a look at it. You've got some legal stuff, you've got some facts, you've got some quantum stuff. And then actually have them write the proposal to the funder and respond to the investment committee questions as to why they might not or would be willing to fund that case and on what basis. And I think if the CAT actually had to do that process and grapple with the multiple uncertainties of that process in order to get one of these things off the ground, they would have reached a conclusion that practicability really is the essence of it, and it's real-world practicability and not theoretically it's a big company, therefore it can do it on its own.
Bad. You know you're being televised.
Yes.
Marcus will be on to you soon. We talked about certification. I do want to talk about decertification. I mean, there was an obvious need for case management all the way through to trial. Now, we've seen, I think, at some points, almost every month, a new certification. And obviously this year has been a bit more turbulence. But those cases are going to come to trial or approach trial. And often they are at the consumer level. And the issue sometimes is how can you get evidence on some of the points? Is it possible? And one of the gripes I have as an expert, is being asked, well, experts, come up with some evidence, okay? You're thinking, well, actually, you can come up with some proxy that's not right, not relevant. You can do all sorts of stuff, and it's up to the court whether it decides, but ultimately, it's an issue of whether both sides have rights. You get to trial, are you able to actually try this case? So, how are you thinking about decertification? Is this the next issue that we ought to be, never mind to certify, but when to decertify?
Yeah, I mean, I'm happy to start on that one. With the defendant hat on, I think it could be one of the next battlegrounds. The CAT's guide to proceedings, its rules are clear about this being an ongoing process, the gatekeeping role being a continuous one, and it was mentioned in the keynote speech this morning as well of the importance of that aspect. I think where I think it will be interesting is, we can all see probably obvious examples where decertification would be appropriate. Something involving the class representative proves to be problematic. They commit a criminal offence, or they have a conflict that is so fundamental they aren't appropriate to represent the class anymore, and an alternative can't be sourced. The whole thing falls apart. Where I think it will be more interesting is if there are situations where the Microsoft blueprint sort of test starts to come into play, best laid plans of mice and men and all of that. Could you get into a situation where it becomes clearer that any kind of aggregation of damages is fundamentally problematic in relation to a claim? And bearing in mind that we're obviously seeing cases as well which have novel theories of harm, sort of increasingly shoehorned in to a class action process, could some of that start to come into play? So, for my part, I can really see that there could be defendants calling on the tribunal as part of active case management to say, well, look, this was certified, but that was then and this is now, and here's what has changed and here's why this should be decertified. And I think it will form part of defendants' arsenal alongside strikeout, summary judgment, various other aspects where you can apply pressure.
Rob? I think, again, looking at it from the sort of real world of funding and claim value, I mean, if you start chopping out causes of action with numbers attached to them, in other words, if you can't run that cause of action, there's an associated loss which falls out, then, of course, the onus is going to be back on the funder. Now, the funders can't control the litigation, but they can control their decision whether or not to continue to fund it. And, all funding agreements have some variation on the right to pull the plug. And there will be cases where if the original quantum, based on the assumptions in the plan, turns out to be vastly less than it was funded for, there will be situations where a funder is going to say, well, I've got a sunk cost of, 15 million. If this goes all the way and the quantum's now down here, that sunk cost may then be, 40 million. two options. One is undoubtedly the one they won't want to do is to write off the sunk cost, but they may want to try and spread the risk with another funder, and all of that will cause potential complication in the middle of a case. So whether or not it's the cat that actually needs, I mean, that is an additional, that's a de facto removal, potentially. Yeah, interesting times.
Yeah, I think funding's another good example of, the action falls apart if the funding disappears. So again, it would be whatever route is taken to bring a claim to an end, but if the funding started to prove fundamentally problematic, you can see that.
But it's directly related in a way to the reasons for certification, suitability, etc.
Yeah.
Exactly.
I mean, the other possibility, of course, is that, a relatively low settlement is reached. That would be, another outcome.
Yeah.
Right,
we've got 9 minutes.
Do you want to say something about pass-on, or should we have some questions?
Well, we should do both. I mean, we can value for money. Pass-on, look, what is it, third time round?
Yeah.
Yeah.
Third time lucky, unlucky?
Third time lucky, unlucky. But we have some background. I mean, we do.
Yeah. Yeah, I mean, it's slightly frustrating that there is a Supreme Court case that sets out a test for pass-on, and effectively at the moment, as things stand, it looks as if the cat has said, well, that doesn't apply, at least it doesn't apply to consumer claims, and that another method might be to start with some theory and then effectively reverse the burden of proof so that the claimant has to sort of come up with some facts as to why there hasn't been 100% pass-on, the claimant being the merchant if there's a merchant level in the case. So I think that it's one of those areas where, again, if you go back to funding, I mean, how do you factor in pass-on when you're starting off a case, when there's so much uncertainty as to how it's going to be dealt with? And I think the reality is you probably can do no more than just provide a series of numbers with different percentages and say, well, if the claim's viable for the merchant level or the business level at a level of 75% pass-on, then that's probably good enough, but we really don't know.
Yeah, I mean, some of the difficulties, it feels like, on the interchange fee litigation, I think there are 2 points. The first is that, at the time that we've had a number of those hearings, we've been talking about a claimant group of, more than 3,000 merchants. So I think, the approach that the Supreme Court set out, which was obviously cast at a high level, doesn't contemplate the sort of scale of what is before the tribunal in terms of the umbrella proceedings at the moment, trying to grapple with, what is effectively a monster that grows another head every 6 months in terms of different features to it, and trying to suggest a viable way to hear pass-on issues and to deliver justice is incredibly challenging. If you are trying to sort of consider an approach that says, well, merchant by merchant, we will try to go and through disclosure and factual witness evidence, expert evidence, demonstrate the level of pass-on, it's just impossible.
Yeah, but I mean, I go back to what Mr. Justice Waxman said in the very first presentation, and I think that his breadth of experience, and particularly GLO experience, gives him a useful perspective. And he said, well, you can do samples. Someone else said in one of the other panels said, oh, GLOs are now moving towards test cases. We have mechanisms for subclasses. To my mind, because something is difficult does not mean difficult, but there's evidence out there. Surely you should try and get a way to get at the evidence rather than simply saying, it's just too difficult, we're going to use some other type of evidence, which potentially is fragile because, it's vulnerable to the claim that it simply isn't good enough as a matter of law to answer the question. I don't know.
Well, look, at least 2 of us are currently involved in this and furiously writing. But I think some of the principles, if we take it away from interchange, is what is the question you're trying to ask or answer? and get expert evidence on. You know, if you're talking about a baked bean cartel, where it's a direct input cost, you may have a lot more agreement than asking about, you know, an overhead. Because, quite frankly, the theory doesn't deal with the overhead. And by the way, the theory is a model. It predicts. We can all recite. Every economist can recite the theory and the prediction. The question is, do you actually think the real world out there is simply opening up your textbook? Well, I would give one piece of advice from other experts. If that is really your view, then all the lawyers need to do is go down the end of Houghton Street to the Economist bookstore, and we're all out of business. Okay? The fact is, facts matter, questions matter, and they are legal questions. They're not economic. It's not an economist opening up a textbook. Yeah. We've got 4 minutes. We're told we've got 4.4 minutes. I'm sure we can get another 10. Let's have a question. Sorry.
Charles.
Do you see opportunities in the UK for opt-outs in the American sense of the word, meaning you have, as you say, Rob, you believe there will be more opt-outs in the future. Could there be also more opportunities to have members of the class excluding themselves and saying we're going to pursue even a group litigation? It could be dozens of them saying we're going to pursue our own claim. Could that be possible, or do you see advantages and disadvantages? Thanks.
Well, I mean, that's what's happened in the States. And what happens in the States tends to travel. So, you know, a lot of the class actions in the States, the large corporates opt out and they do their own deals either separately or in small groups. And the answer to the question is, I think it's very much fact and client specific. There are so many factors that go into the decision of a business to put its head above the parapet, safety in numbers, fear of retaliation, you know, let alone the financial ones, let alone their balance sheet. Yeah, I mean, let's take a client of mine, Microsoft. Balance sheet, I don't know how many, maybe 90, 100 billion sitting there. Class action, they're not going to stay in an opt-out class action. They'll do their own thing, and they'll fund it themselves. They don't need funders. That's at one extreme. And then you could have at another extreme, a private, family-owned company you know, as many companies are, particularly on the continent, where the owners want to retire and sell the company on, and you know, they're either on the receiving end of a case or they could bring a case. But would they want to do it in which way? Would that affect the value of the business, the perception of the business? You know, those are just off the top of the head. So the answer to your question, the straightforward answer is yes, we will see much more opt-out over time. And we may even see collective opt-outs in groups of opt-outs.
And in practice, people are considering this. And when you ask a question, can you say where you're from as well? Any more questions? No?
Ooh.
Going?
We must be the only panel to.
Well, I've succeeded. We've only got 1 minute left, and you can go to lunch.
We managed to dodge pass on enough. We didn't have a full-on squabble.
Yeah. Not yet. Thank you very much, everyone.
Thank you.